everyone, and thank you so much for joining us today for our presentation on the E-2 visa. My name is Dustin Saldarriaga, and I'm a senior associate at Scott Legal PC. We are very fortunate today to have my colleague Jiyae Hwang here to present with me. Jiyae will be going over the E-2 visa requirements and the process, and then I will be talking about some specific aspects of the visa that are worth keeping in mind. A few things to note before we get started. Our firm is a full service immigration firm. So though we do focus on business immigration, including the E-2 visa, we handle the full spectrum of U.S. immigration law, whether that is family-based green cards, employment-based green cards, temporary visitor visas, student visas, really the whole gamut. So if you have any questions about U.S. immigration law, we do hope that you will reach out to us for assistance. After this presentation, you will receive an email with a link where you can sign up for our future webinars. We try to do at least 2 webinars a week, and again, those do cover a variety of immigration topics. In that email you'll receive, you'll also get a copy of the PowerPoint presentation that you see on your screen, as well as a comprehensive guide on the E-2 visa. That email will also have a link to our YouTube channel. We're very proud to put very high quality, free information up on YouTube. We try to answer what we consider to be the most important and most common questions we get about the full spectrum of U.S. immigration law. So do check out our YouTube channel. On our YouTube channel, we do include the full-length recordings of this webinar. This webinar is being recorded. It will be posted to our YouTube channel. If you have a question during the presentation, please do send it in through either the chat function or the Q&A function on Zoom. We do plan to get through all questions during the presentation. We'll likely save those for the end of the presentation, but do send those in. We love responding to questions. Without further ado, I'm going to go ahead and pass it off to Jiyae to talk about the E-2 visa requirements.
All right, thanks so much, Dustin, and welcome everyone. So let's start with discussing the requirements for the E-2 visa. So what are the E-2 visa requirements? Now, as a general overview, and as many of you may know, the E-2 visa is a non-immigrant visa for investors who are seeking to come to the United States to develop and direct a U.S. enterprise that they have invested in. And a non-immigrant visa here means that it is not a green card, but an E-2 visa holder can actually continue extending the visa indefinitely as long as the applicant continues to meet all E-2 requirements. And to get an E-2 visa, the applicant can either purchase an existing U.S. business or start up a new enterprise in the United States. So to be eligible for the E-2 visa, you must meet certain requirements. So the first requirement is that you must be a national of a treaty country. So the E-2 visa is an option available to nationals of countries that have signed an economic treaty with the United States, and this includes many countries around the world, in all continents, including, for some examples, Canada, Mexico, UK, New Zealand, Australia, Singapore, Jamaica, Philippines, etc. It is not available to nationals of certain countries that have not signed such a treaty. For example, India, China, and Russia do not participate in the E-2 visa program. However, if you are a dual national of a non-treaty country and a treaty country, then you could use the treaty country's passport to apply for the E-2 visa. The other requirement is that you must own at least 50% of the E-2 company. And when I say E-2 company, this means the U.S. enterprise that you are purchasing or setting up in the United States. The third requirement is that you must make an investment. And what does this mean? So you can make the investment either through buying an existing company or setting up a new company. Now, the investment must be at risk. So what does this mean? So this means money was actually spent as opposed to just sitting in a bank account. So let me explain a little bit. So if you are creating a startup in the United States, money needs to actually have been spent towards concrete things that is related to setting up the business before you apply for the visa, which shows commitment towards, the investor being, committed to the enterprise. Now, a common question for applicants applying with the startup is that does it count as investment if you just create a business bank account with your company's name, and if you just transfer the money from your personal account to the business bank account, does that in itself count as investment? And the answer is no, because it won't be considered money placed at risk, since you can always transfer back this money to your personal bank account without any restrictions. And if you are purchasing a business, the money must already have either been transferred to the seller, the full purchase price, or must be placed in escrow. And the escrow's only condition would be the approval of the E-2 visa to release the funds. So that will be, considered money placed at risk. Now, the amount should also be substantial. And what does it mean, a substantial investment? Now, there is no hard and fast minimum that is required under the regulations or the law, but substantial here means generally in terms of making all expenditures necessary to start the business. And if you're purchasing a business, the purchase price would be the substantial price. And if you're setting up a new startup, the government will expect that you have spent everything that is necessary to, get the business ready. If there's any equipment that's required, you would have purchased the equipment. If you have, office space that is needed, you would have already signed the lease for that, all of these things. So everything necessary for the business to be up and running must have been spent. Now, let's talk a little bit about the source of funds. So, another part of the E-2 application is proving where you obtain the money that you use to make this investment. And the requirement is that the applicant must prove that the source of the funds was legitimate. So this can be, savings from your employment earnings. It can be a gift from someone you know. It can be even a loan. Now, loans are okay, but it must be secured. It cannot be secured by the E2 business or any of the E2 business's assets. So if you're using a secured loan, then it must be secured with some unrelated property that you own, for example, your own residential house, for example. And if you take out a loan against your house unrelated to the E2 business, you could use that as your source of funds. If you are getting a personal gift or a personal loan from someone you know, then also we need to go one step further and provide the source of funds for where the gifter or the loaner obtained their obtained their money from. So, for example, if you obtained a gift from someone and that person, obtained this money through employment savings, then we would, include a copy of the gifter's tax returns to show that they have actually earned the money through income. Now, as I mentioned before, the amount of the investment must be substantial. So let's talk a little bit about what are some typical expenditures that can constitute an investment amount for when you're setting up a startup. So this can include things like inventory, equipment, the cost of setting up a website, cost of purchasing office supplies. If you rent an office space or warehouse space related to your business, all of these costs can go towards typical E2 expenditures. If you have spent money to set up your business entity, those kinds of legal fees can also be added towards that. And I did talk a little bit about this in the bullet above about when you're starting a business versus when you're purchasing an existing business. So one other option that you have if you're purchasing a business to qualify for the E2 visa is using an escrow to sort of hedge against the risk that perhaps the E2 visa may not be approved. So using an escrow account is the option available. If you're purchasing a US business, you can work it out with the seller to have an arrangement that all of the purchase price will be placed in the escrow account. And if and when your E2 visa is approved, those funds would then be released to the seller. And that kind of arrangement is acceptable if it is the only and sole condition of the release of the funds. There cannot be any other conditions to the sale, but the only condition for the release of the funds should be the approval of the E-2 visa. All right, so we'll move on to the next slide. So the other requirement for the E-2 visa is that the business cannot be marginal. So what does it mean to not be marginal? It means that the business must be able to hire and maintain U.S. employees other than yourself or, any family members. And this really goes to the revenue generation potential of the business. So the E2 business really cannot just be, a kind of a sole person, sole proprietor or sole one person shop, so to speak. It must have additional employees other than you. And the profitability of the business must be enough to show that you will be able to maintain these jobs, to hire US workers. And we generally recommend, the business planning to employ at least 4 to 5 employees within the next 5 years of operations to meet the marginality requirement. Now, the other requirement for the E2 visa is that the business must be real and operating. So what this means is that the business either is already taking revenue or very closely about to start running once the visa is granted, which means everything that is necessary to, if you are establishing a startup, for example, everything necessary to get the business up and running must already have taken place at the time you apply for the visa. So the U.S. Legal business entity must be established. If you need a business space, the business space must already have been secured. If you need any equipment or furniture or things like that, they're already should be installed in the office space. Any required licenses must already have been secured if you're operating in a field that requires such licenses. And ideally, you would have client contracts in place that shows that there is imminent demand, for your company's work. So really what they're looking for is the business basically ready to go once the E2 visa is granted. The other requirement is that the applicant must be coming in to the United States solely to develop and direct the E2 enterprise. And so one thing that is important to note is that the work authorization that you will get when you're approved for the E2 visa is limited to your particular E2 business that you originally applied under. So with the E2 visa, you can't come in on the E2 status and start working for other companies or set up side hustles if it involves different U.S. entities. All of the work that you must do in the United States must be through your E2 business and must be part of operating your E2 business. Now, another part of this requirement is that the government will expect that the applicant will serve primarily executive duties of developing and directing the business, and this person will hire employees to perform a lot of the other on-the-ground administrative kind of functions. So you will primarily be leading the company as opposed to, doing direct, focusing on doing direct services or on-the-ground work when you're in the United States. The final requirement that I'll go over is the intent to return to the home country upon the expiration of the E2 visa. And as I mentioned before, the E2 visa is a non-immigrant visa, which means there must be a showing that your intent to come to the United States to work is temporary, to work on the business. And this requirement actually is usually satisfied in most cases by a signed statement of the applicant to that effect. So you can provide a declaration that, hey, my intent is to come and work on this business, and after my business is, done, my business project is done, I will leave to my home country. So a signed statement is usually what we include. All right, so let's go a little bit into the weeds about the details of the requirements. So who can apply for the E2 visa? Now, as I said before, the applicant must be a national of a treaty country. And what does it mean to be a treaty country? It means that, there has been an economic treaty to that effect signed between the United States and that particular country. And actually, it is easy to look it up on Google. You can search for treaty countries, Department of States, and you will be able to see a list of the current list of all treaty participating countries. And this includes many countries in Europe, Africa, Asia, really in all continents. And for some examples, as I mentioned before, the UK, Mexico, Canada, Chile, Philippines, Japan, Egypt, and many, many other countries. And it is important to note that this list is updated from time to time. So, for example, Israel and Portugal were added relatively recently for the E2 visa program. And some countries do not participate, but it is also important to remind you that if you are a dual national and if you have a passport in, for one of the treaty countries, you can use that passport to apply. And it is also important to note that nationality in this context does not depend on the country of birth, as opposed to, the green card context where the country of chargeability is the country of birth. In this context, being a national means you have a passport in that particular country. And as I mentioned before, there are two options for obtaining an E-2 visa, which is first to start a business in the United States, and the second option is to purchase an existing US business. So you do have that option to choose. All right, so we will move on to the next slide. All right, so how long is the E-2 visa valid for? And this is another common question. And the answer to that is it depends on your country of nationality, the country that you apply the E-2 visa under. And the list of the differing validity periods, you can also search for that by Googling reciprocity schedule, Department of States. And you will be able to see that for many participating countries, you may get a pretty lengthy visa validity period up to 5 years for many countries. Now, for some countries, the validity period of the visa can be as short as 3 months. Now, however, it is important to note that the length of the E-2 visa is a different concept than the length of the E-2 status, which is granted for 2 years upon each entry. So a good way to think about this is that the visa is kind of an entry stamp. It's a ticket that you present to the United States border to be able to, be granted entry into the United States. But once you're in, the length of the time that you're granted to stay and, continue developing and directing your business is 2 years. So even if you have a 3-month long visa, as long as you present this ticket to entry at the border and, within the validity time of the original visa, once you're in, you will be given the 2 years, the same as everybody else, to develop and direct your business. If you leave, within those 2 years and then try to come back in, then you may need another visa, right? But that doesn't mean that, your length of stay in the United States will be limited to the visa validity. So that is a distinction that is important to keep in mind when you're looking at the visa validity period. All right, so now then let's focus a little bit on the E-2 visa investment. So let's first talk about how much investment is really enough. And we can, discuss a little bit more into the specifics of the amount of investment that is expected. So as I mentioned before, there is no hard and fast minimum in the regulation of law. And what amount is considered substantial will actually depend on the type of business that is being started. So for example, let's talk about an office type consulting business where it's a service-based enterprise. So, really the human capital is what, you may need to provide those kinds of services. In that case, the startup costs may, not be as higher as, a different type of business, such as a manufacturing type of business or a retail type business that typically require higher startup costs to get everything, set up on the ground. So for a consulting firm, for example, you may need a business lease for office space. You may purchase some computer equipment. You may set up some furniture for the office and hire employees, and maybe that's all you need to do. By contrast, let's say if you're setting up a restaurant, that kind of business would definitely require much higher startup costs to start. So that will affect the amount that the officer will have in their heads when they're looking at your petition, whether the investment was substantial. So let's talk a little bit about the proportionality test. So the proportionality test basically means is that the smaller the total cost needed to start up or purchase a business, the higher proportion of these costs the government would expect that would already have been spent when you apply for the E-2 visa. So for example, if it's a small consulting firm where the typical startup cost is about like $80,000, let's say, for example, to set up or purchase, then the government will expect that the applicant would have spent 100% of all of the 80,000 required to set up a company like that. By contrast, if the applicant is applying in relation to a 10 million, manufacturing, factory or some kind of operation like that, then even if you spent a smaller portion of that 10 million required, the government will likely consider it a substantial investment, given, the high cost of the business to become operational. Now, when you are purchasing a business, what you want to do is compare the cost of purchasing that business to the fair market value of that business, considering that you bought it in the open market. So if you did buy the business in the open market, then you likely did pay the fair market value, and that would be considered a substantial investment. Regardless. Now, if you have bought a business from someone you know, or it was, from an acquaintance or such that it was a closed market transaction, it could be a benefit to get a letter from a CPA, for example, an independent professional, confirming that the purchase price that you paid is indeed equivalent to the fair market value of the business, based on its performance and market conditions. When you're, starting up a business, for example, you can also benefit from adding business articles that also talk about the typical startup price of those types of businesses. So there are many different ways you can argue substantiality. Now, another thing to note before we move on is that different consulates around the world do have different standards on what they see as a substantial investment. And there are certain consulates that would consider any investment below 100,000 US dollars as insufficient. So definitely speak to a lawyer who has this nuanced understanding of those different expectations in consulates when you're, preparing, a E-2 investment, especially with a lower investment amount. All right, so then that segues into what are some strategies then that you can use to deal with a lower investment amount, if that is what you're working with. So one strategy is definitely to stress other factors that are stronger about the application. So for example, experience is one thing. If you're a highly professional, person who brings, unique experience to really be able to develop and direct the business into a high growth state, that you can emphasize that. What about employees, right? If you already have hired an employee, when you're applying for, the application, that could help your case. Also, in meeting the marginality requirement, that the business would, have a stronger profit potential than just supporting yourself and your family. The type of business also is an important factor. So if you are indeed setting up a consulting type, office type business, you can stress that given the type of business, what you have spent is actually more than enough to, that is average in the industry to get this business up and running. Another thing that can be helpful is to show that you already have contracts or letters of intent from clients that are willing to, hire your company for those services. That can show that really your business will be a vibrant, active, and real and operating one, and that whatever you have spent is actually enough to, really get your business up and running. Another strategy you can use is to obtain a letter from a local chamber of commerce that can confirm that, oh, this, type of investment is typically enough to, get a successful startup for this type of industry. You can also highlight ongoing company activity or sales if you have already started earning revenues through your company. That can be a highly positive factor. Another strategy is to draft a strong business plan that can show a very detailed 5-year projection on how you're going to, earn revenues, how you're going to get clients, and the growth trajectory of your company that will show a non-marginal income. And as I mentioned before, hiring US employees prior to applying, although not technically required, is a very good idea to definitely meet many different criterias, including the marginality criteria, the real and operating criteria, and also could support substantiality. Now, and the CPA letter, I did mention this in one of the earlier bullets, but that could be helpful to confirm that that kind of investment is actually enough to get a similar type business up and running. All right, so that now here, let's talk a little bit about some common E2 visa expenditures that you could use to, you know, build up the investment amount in the case that you are applying with a startup and you're setting up a new business. So here are some examples. It's typical for a business to spend on setting up a website and web hosting services. That's a very typical expenditure. Computer equipment such as laptops, desktops, printers, scanners, and tablets. That's also a very common business expenditure that you would expect when you're setting up a new business. Inventory, if that's, if you're in the retail business or something like that, that can definitely be a part of your startup expenses. Furniture, only if it is used for business purposes. So if you will actually set up a business space and if you'll be greeting clients or things like that, then definitely having furniture to set up that area would be relevant to your setting up your business. Trademark and intellectual property, if it is relevant to your business project. Employee payroll or independent contractor payments is also a very good expense. If you already hired an employee, any salary that you pay the employee and also any costs that you paid to the payroll provider to set up that system can be considered as a valid part of your setup, startup expenses, as well as payments to contractors that did the work, related to setting up your business enterprise. Legal fees, you can include things like, if you hired a lawyer to review some contracts that is related to setting up the business, definitely something like that. And also legal fees that you pay to us, immigration lawyers, to help drive forward your E2 case. You can include those fees. And a business lease is also a very popular item to include in the expenditure list. And it is actually also could be a good strategy to prepay some of the rent if you are trying to, show a larger expenditure amount. It is possible to include all of the expenses that you already paid, although you cannot include future expenses. So if you prepay, let's say 6 months rent or a year's rent, you can include all of those amounts that you've already paid into your expenditure amount. So that could be one strategy if you're struggling with working with a lower investment amount.
Great, thank you, GA. So I will talk about starting off with strong expenditures versus actually let's repeat I think some of what GA was saying. I'm not actually sure. Ah, yes, okay. So I think there were two parts to that. GA,
No
I
worries.
can go ahead and do these.
Yeah, let's do.
Okay, so basically what are common or good E2 expenditures, as GA was saying, are expenditures that are necessary for the business to be operational. So when you show up at the consulate, you're sitting in front of the consular officer, and basically you want them to see that you have bought everything that's needed for this business to be operational. So if you are starting a consulting company, for it to be operational, you're going to need some space. You're going to need some office furniture. You're going to need to market. You're going to need a computer, maybe a printer, maybe a scanner. You're going to need to have formed the LLC. You might need some form of insurance, maybe malpractice insurance if you're a law firm. If you are a business that is doing construction work, you may need a vehicle to transport workers. So think about sitting in front of that consular officer and they say, okay, so you say you want to start a business in the US, prove to me that you're serious about this. One of the best ways you can do that is to say, I have committed all of the money needed to make this operational, and look, here's how I've spent it. So that kind of explains what the common expenditures are. I'm not going to go into each of these. I think GA did a great job. But let's talk about some weak expenditures. So weak expenditures are going to be those that are not clearly necessary for the business to begin operations. For example, if you are traveling to the US to sign a commercial lease for an office space, that's not absolutely necessary to include your travel expenses. Your travel is not necessary for the business to become operational. So travel expenses related to the business would be weak expenses. We would generally not include those. Similarly, accommodations like a hotel, um, entertainment. If you're entertaining prospective clients, that tends to be a weak expense and is not typically seen by consular officers as necessary to the business. So, if you have questions about this, we're happy to talk about it through a consultation. But in general, the way to think about these expenses is strong expenses are necessary for the business to be operational. Weak expenses are those that are not clearly necessary for the business to be operational. If something's on the line, I think it's always helpful to just imagine that you're sitting in front of the consular officer and they're asking you, okay, tell me, why is your flight to the United States absolutely necessary for this business? And if you have a very strong argument and you feel confident about that argument, it may be that you can include that expense. But if the argument is, you know what, I'm going to be pretty defensive in that discussion, I'm not sure if the officer would be convinced, it's probably a weak expense that should be excluded. Um, Common challenge. Now we're going to switch gears. We're going to talk about some specific categories of E2 businesses that tend to be more difficult than others. One category of businesses that does tend to present challenges. This being said, we help clients navigate this all the time. So these businesses are regularly approved. They just do present certain challenges that you need to be aware of and to navigate. One of those categories of businesses is consulting businesses. And I would say law firms are probably in the same category. Law firms face similar challenges to what I'm about to describe. The reason why consulting companies are challenging, by and large, is that they don't need a lot of money. I know that there is a question about this. How do you establish a substantial investment when starting a consultancy where you just need a laptop and your skills and time to launch the business along with some marketing? You don't need a lot of money to start a consulting business. You don't need a lot of money to start a law firm. Like the person who asked the question said, you oftentimes just need a desk, a laptop, an internet connection, maybe malpractice insurance, a little bit of advertising. But once you buy all of those things, you're probably at about 15, maybe $20,000 all in. So what do you do in that case? What we always do, step one is to always look at what's been spent and to see if there are ways to augment those expenditures. Are there ways to increase that? So yes, a consulting business should have an office space. Can you pay that rent in advance? Jiyae mentioned this. So maybe you rent a private desk. It is $200 or $300 a month. Can you pay for 6 months in advance? Can you pay for a year in advance? That's one way to augment that expenditure. Marketing is a common area where you can augment your expenditures. So if you've already paid for a few Facebook ads or Google ads, can you buy more? That is a way that we're always looking for ways to spend money that actually benefits the business. So hopefully increasing your marketing does benefit the business, the bottom line. We generally don't recommend spending money just to spend money. We always try to align it with the business itself and its bottom line. And marketing is typically a good way to do that. So let's say that you've already done those things. You've paid for the office space in advance. You've spent as much on marketing as you can. You've spent money on a very nice website. What else can you do? Probably the best thing you can do for a low investment amount is to hire an employee. So hire someone in the US who can serve really any role for the business. They could work as a marketer, they could work as an office manager, help get your business set up. Maybe they could design the website and you could have them on as a marketing employee. That is a wonderful way to strengthen the application because it does two things. The first thing it does is it gives you an opportunity to increase your investment amount. You're spending money on their salary, on their wages. but it also shows the consular officer that the business really is real and operational. So much so that you already have an employee. If an employee is not possible, an independent contractor is better than not having anyone. So going to what I was saying about showing that the business is operational, keep in mind the reason for the substantial investment requirement is that it is basically a test to show that this is a real and legitimate business. So if the officer is skeptical about the investment amount and they say, we don't think you've invested enough for this business to be operational, one of the strongest counter arguments you can have to that is, but the business is already operational. If you look, I already have an employee. If you can get client contracts, that's another way to really strengthen your application in spite of a low investment amount. So what I like to say is hiring employees really is a make or break factor. So it is a make factor because if you can show that you have hired employees, then it can actually counterbalance some of the weaknesses in the application, like a low investment amount. Similarly, if you fail to convince the consular officer that your business will employ US workers, it is very unlikely to be approved. So you really do want to focus on that employment piece, especially if you have weaknesses in the application, like a low investment amount. So another category of weak, relatively weak E2 or challenging E2 businesses is equity trading companies. And I'll also include in this category real estate investment companies. So these are businesses that both basically take capital, they take money, invest that money, and the purpose is to generate profit. And the reason why these businesses are challenging is that first of all, they tend to be passive. They don't tend to require a ton of time from the business owner. By and large, or I should say that is the perspective of the consulates, is that they don't require the active participation of the owner. But second of all, they don't, in the mind of the consular officers, they don't tend to require employees. So, one person could take $100,000 and start investing in stocks, spend a couple hours a day doing that, and say, I have a business. They don't clearly need employees. It's not clearly requiring a lot of time of the investor. So if you do want to start one of these companies and use an E2 visa for them, what can you do? One of the clearest things you can do is to make it clear in the application that you will actually require employees. So make it clear that you have interest from a large number of clients. So clients that go beyond your friends and family, that you actually have a number of people who are not related to you or who are not your friends necessarily, who want to invest their money with you. And because of that demand, you actually are going to require the services of an office administrator, of a marketing agent, of a stock analyst, of any number of positions. So you want to make it clear that the demand and the services you're providing are actually going to require US employees. Better yet, hire those employees. Keep in mind, you don't need to be in the US to make a business operational and to hire employees. It may be more challenging to do that, obviously, if you're not here, but it's not absolutely necessary. And we actually have many clients who have been operating a business in the business is inside the US, the owner is outside the US. They've been doing this for a year, 2 years, 3 years, 5 years, and they say, you know what, now is the time that I want an E2 visa. So the consulate is aware that people do this. If you are able to do that for one of these types of businesses, it probably would greatly benefit the application to show we already have traction, we already have clients. So this is not a type of business that is going to be able to operate without employees. The other thing you want to do is prove if the industry is highly regulated, which in equity trading or investment it typically is, you typically need a permit or a license from FINRA. you need to take, the Series 7 exam or whatever series exam you need to take to show that you're qualified and approved to manage other people's money responsibly as a custodian. You want to show you have all of those licenses and permits. So in your application, you're going to show I have all of these approvals, all of the permits, all of the licenses. Because again, if you show up at the consulate and the officer says, so if I give you this visa today, will you be able to fly to the US and start operating the business tomorrow? If you say, well, no, I need a license to do that, that is definitely going to be a detractor, a negative aspect of your application. So you want to be able to tell the officer, all I need to operate this business is the visa. I've lined up all the approvals, all the licenses. So all I need you to do, consular officer, is approve my application. So, what are common reasons for E-2 visa denials? We've already touched on a number of these. A low investment amount is a reason for a common reason for visa denials. Um, I will say we have a separate uh, we do have, like I said at the start of the presentation, we record all of our webinars, and we do give this webinar somewhat regularly. So if you are concerned about a low investment amount, it may be worth seeing some of our other videos on YouTube, which are slightly different depending on the questions we get, but also schedule a consultation. That's probably the best thing you can do at an early stage if you're concerned about a low investment amount, because there is a good amount of strategy around those applications to strengthen certain aspects of the application if the investment amount is low. The investment amount does depend, though, on where you apply. So, for example, USCIS, if you apply within the United States, if you're already here, say on a student visa, and you're applying to USCIS, they tend not to care as much about the investment amount. They care a lot more about the money, where the money came from. Consulates, on the other hand, do tend to be more strict about the investment amount, but they're less strict about proving where the money came from. Um, Also, not all consulates are created equal. So some consulates will be okay with a lower investment amount, while others want to see a very high investment amount. And we file these applications around the world. We're familiar with consulates around the world, and we can help you as our client figure out which consulate is an ideal fit, or if USCIS might be the most strategic choice. Like I said, the nature of the business is also a common reason for denials. If it is an equity investment business or a real estate investment business, those are risky. The location or venue, as I said, not all consulates are created equal. You can be strategic about where you apply. Another very common reason for denials, and this is important to keep in mind, is if you already have a similar business in your home country. We run into this all the time. People will reach out to us, schedule a consultation, and they say, I want to start a consulting business in the US. And I've actually been doing it for 15 years in London. And we say, that sounds great. You have a lot of experience doing that. How many employees do you have in London? And they say, none. It's only me. And I've been doing that for 15 years. That is not that is not a strength, but it's also not something, it can be overcome. But what you need to understand is that the consular officer is going to likely ask the exact same question. And the next question they'll ask is, okay, if you've been doing this for 15 years in the United Kingdom and have not created jobs for workers, why are you now telling me, or why should I believe that you will now create jobs when you do this in the United States? So you need to have a very good, well thought out plan. Oftentimes, this is a key purpose of a business plan, explaining what you're going to do in the US to create those jobs. So simply having a business abroad and having done this before isn't necessarily a strength. It could actually be a weakness. An applicant could actually be in a better place had they never started that business abroad if it didn't create jobs. Now, again, you can explain this. Just know that it is likely a question that is likely to come up at the consulate. Issues with the adjudicating officer. Consular officers have a huge amount of discretion on these applications. They can basically deny based on how they feel. whether they like you as an applicant, whether they like the clothes you're wearing. So consular officers' decisions, it's very difficult to challenge the decisions. They know that unless it's related to a clear error of law, which is difficult to show. So, you do kind of roll the dice based on who is interviewing you. That's the downside. The good side is that even if you're denied, you can oftentimes ask the officer why you're being denied. They will usually give you reasons. So it may be the investment amount is low. It may be I don't think you're going to hire employees, and you can go back. You can strengthen the application by investing more money, by having a more robust business plan, showing you'll hire workers, and apply again. And oftentimes, consulates will try to assign you to a different consular officer than you got before. So, in general, there's not a bar to applying again. And finally, sometimes people come to us after having been denied, having applied on their own or with another attorney, they've been denied, and we look at the application that was filed and they just didn't qualify. It could be that they applied with a visa, or sorry, with a passport that's not a treaty country passport. It could be that they don't clearly show they're going to hire workers, that they say, I'm going to operate this solo. Could be that it's clear they're not going to generate enough money to support their family. So you do need to make sure that you meet the basic E-2 requirements that Jiyae went over at the start of this presentation. So adjudication trends, the big caveat to everything I'm about to say is that we have a new president, a new administration that started a week ago. Donald Trump has issued a number of executive orders, many of which talk about extreme vetting, and that means that consulates are supposed to ask many more questions than they were. They are supposed to scrutinize applications to the maximum extent they can, which is basically a way to say that if there is any basis to deny an application, you should not hesitate to use it. That's the way I interpret the executive order. So does that mean that every application will be denied? I don't think so. Part of the reason I say that is we've already been through one Trump administration. E-2 visas were approved with regularity in the first administration, and I think the same will be true this time around. I think it's helpful to keep in mind that the E-2 visa is a job creation visa. So these are not the E-2 investor visas are not for people to come to the US to compete with the domestic labor market. They are for people coming to the US as entrepreneurs, which by definition, as we've talked about a lot in this presentation, you must generate jobs. You must create jobs for US workers. So that being said, we do think people will face more questions at consulates. We do think that administrative processing, which is where applications go through increased security screening, we think that will probably become more common. But I don't think that we anticipate seeing this channel close or be severely restricted. I think we're still going to see E-2 visas going through the process and being approved. So even though I would say you need to have a strong stomach and expect longer timelines than we've seen in the past, I think you should keep hope that this is a channel that you can navigate. And it's also, I think, especially important to work with an attorney under this administration, more so than under the Biden administration. Current timelines, again, this is based on applications that we saw under the Biden administration. Toronto has been relatively fast. So from the point of filing the application to actually having an interview and getting your visa, we were seeing timeframes of between 1 to 3 months. London is a little bit longer, but they are also working through their applications. I like to use the 3-month time frame. That was the time frame under the Biden administration. So from the moment you submit an application to the moment you actually have your interview, expect about 3 months to pass. Now, again, that could and likely will become longer under the Trump administration, but that is the timeline that we were operating on as of a couple weeks ago. USCIS versus the consulate. I've mentioned this. USCIS does tend to be more strict about the source of funds, though less strict about the investment amount. Consulates, you really do need to think about which consulate you're applying at. Some have page limits, which means you cannot include all of the source of funds documentation, and they tend not to scrutinize that. Some consulates don't have page limits, so you need to basically treat it as a USCIS application and document the entire source of funds. So a lot depends on where you're applying. I do think that in light of the Trump administration's restrictions on the borders and likely difficulties coming into the country, we probably will see more USCIS applications being filed. That is definitely what we saw under the first administration, although a lot of that was because of COVID restrictions. The other thing to know about USCIS is that it is much more expensive. A USCIS application, you're going to be paying filing fees of, I believe, around $500. I don't have the exact dollar amount in mind, but a consulate is going to have filing fees of 315. And then you do have to pay the reciprocity fee on top of that, which, as GA talked about, depends on your country. Many countries don't have a reciprocity fee. Other countries like Australia have an extremely high reciprocity fee of $5,500 per person. USCIS, even though the fee is going to be $500, if you want that application to be expedited, so decided within 20 business days, you are looking at an expedite fee of almost $3,000. So USCIS does tend to be more expensive by and large, though again, that depends on your country of nationality. And post-specific considerations, I'm not going to say much more about this. I've already talked about it, but reach out to us if you're looking at applying at a consulate, and there is strategy behind, what are different consulates looking for. Issues and complex areas to keep in mind. Do I need to hire employees before I apply? No, but if you do not have employees, you need a very good business plan that convinces the consular officer that your business will hire at least 3 full-time equivalent US workers over the next 5 years. The earlier you can hire them, the better. Complicated source and trail of funds, especially again, USCIS filings. As GA said, loans and gifts are generally acceptable. The exception is if the loan is secured by the E-2 company or its assets. You cannot use loans that are secured by the E-2 business. But if you are using a loan or a gift, say from a family member or a friend, that is generally fine. Keep in mind, as GA said, you do need to document exactly where that person who gave you the money got those funds. So you cannot get around the source of funds requirement by getting money from someone else. The other area that I sometimes see that does create issues is cryptocurrency. So if you made a bunch of money through Bitcoin and you want to use your Bitcoin gains toward an E2, that can be difficult because it's very difficult to document where those funds came from. It's interesting, though, that clearly the Trump administration is very pro crypto. So you might see this being relaxed a little bit. It hasn't happened yet, but might happen. You can apply for, and you can have 2 E2 visas supported by one business, and it's 2 E2 investor visas supported by one business. The requirement is that an E2 investor must own at least 50% of a business in the US. So you can have 2 people each owning 50%. That is the requirement. They have to own at least 50. So the only way to have 2 E2 investors is 50-50 ownership. If the business is owned by 2 E2 investors and they have different E2 nationalities, so for example, if someone with a Spanish passport and someone with a UK passport join forces, own an E2 company together, that company will have dual nationality, Spanish and UK nationality, and they could hire E2 employees from either E2 country. So that's an interesting aspect of the E2. Substantive changes to the E2 business after filing. Sometimes you file the application, you tell the government what the business is going to do, and it evolves. You find another opportunity, you want to expand the business. You need to be very careful doing that. That the reason is someone who gets an E2 visa only has work authorization in the US to run that business. You cannot work on a separate business. You can't drive for Uber. You can't work at Starbucks. You can only work for the E2 company. So what should you do? If you have any hope or idea at the time you're applying that, you know what, we might go into this other field. We might start consulting on the side. We might open a cafe on the side. Include that in the business plan, include that in the application, and you can frame it as in the future, we do anticipate expanding to begin offering consulting services, to operate a coffee shop. You can include that in the scope of the plan so that when the government approves it, that's already part of the scope. And you don't have to worry that that is a change from what you represented to the government. Um, if you didn't do that, then sometimes you may need to ask USCIS to amend the approval. And that is a process that we can help with. I would say schedule a consultation though. Finally, family business purchases. You can purchase a business from family. Be very careful doing so. You want to be able to prove that you paid the fair market value for the business. This is what Jiyae was saying, the substantial amount. When you're buying a business, a substantial amount is generally the market value for what you're buying. So if you're buying a business from a family member, say you're buying 50%, um, you need to convince the officer that you paid 50% of the fair market value. So if you're getting a huge discount, that can very likely be a problem in the application. With that, we have some great questions that rolled in. GA, if it's okay with you, we're running low on time, so I might run through
Yeah, just let's do
if
a
that's all
couple,
right.
and some of them
Yeah.
are already answered. So yeah, go
Oh,
ahead.
good. Perfect. So I saw a question that I I'm not seeing it right now, but let's just run down the list. Yes, I love this question. So the intent to return to the home country upon expiration of the visa and business cannot be marginal appear to contradict each other. Does USCIS expect the business owner to shut down the business and fire everyone after 5 years? Absolutely not. These two requirements, even though they might seem like they're in conflict, they actually are not. And the reason is the intent to return home after the visa expires. The better way to say that is you can't use an E-2 visa to enter the United States and adjust status to a green card. Okay, so you can't go to a consulate, apply for an E-2, and know I'm going to use this E-2 to enter the country. And then once I do, I'm going to try to change status based on my brother being a US citizen or based on my wife being a US citizen. It is fine if your mind changes while you're in the US and you were honest at the time you applied for the visa and were honest at the time you entered. But you can't use the visa to pursue a green card. So that is the representation you're making. It is, I am seeking an E-2 visa to run this business. And if I end up renewing the E-2 visa at the end of 5 years because I have 20 employees, that is perfectly fine. But what you cannot do is enter the US to pursue a green card. So hopefully that makes sense. Our firm was founded on an E-2 visa, has been operating for over 10 years on an E-2 visa. Clearly, we don't fire everyone. At least I hope that's not the plan at the end of the visa status. It is not what the government wants either. An E-2 is meant for a foreign national to build a business in the US and create ongoing employment opportunities for US workers. Can we buy a business that currently is making a loss? You can, but what I would say is you, again, imagine yourself in front of that consular officer. You want to put yourself in the strongest place possible. So if you have the opportunity to buy a business that is not making a loss and that is clearly showing it's generating enough profit to pay you as the owner after paying the employees, that is the best way to strengthen your position when you're at that consulate. You don't want to start the consular interview being on the defense, right? Like, let me explain away the problems with my business. Find a business that already has employees, that is already paying employees, and that after paying those employees is generating a profit for the owner. That is an easier, much easier case to make. If the visa is valid for 5 years and the status expires in 2 years, the investor will have to apply for an extension, or will we have to go out of the US and come back? So typically what people will do is they will leave the US and come back. So if you have a visa, an E-2 visa, you're able to leave the US, come back in, generally no problem. With the new administration, you might have questions. What are you doing in the US? But again, during the first Trump term, people were able to leave and enter the US with an E-2 with relatively minor issues. I'm going to set aside COVID. But so what most people do is they leave and they come back in and they get another 2 years. That is far cheaper, far faster, and far easier than applying for an extension with USCIS. But if you're in the US and Trump ends up shutting down the borders like happened because of COVID, it may be worthwhile to apply for an extension within the US, but hopefully we won't be in that situation. For prepaying an office lease, should we show 12 months prepayment or should we show 6? Depends on what money you have and what you want to spend. I will say, the officer wants to see the full spectrum of money, of items being purchased. So if you're paying for 12 months in advance and that constitutes 80% of your investment, that's a problem. You want to show, you've spent all the money needed and you cover the full spectrum of things that are needed for that business. But that being said, if you're looking for ways to increase your investment amount, generally speaking, we haven't seen problems with people paying 12 months in advance. Why would someone hire an employee ahead of acquiring a visa if they don't know they can operate and direct activities yet in the US? Because you can operate and direct activities in the US from abroad. And many people do it. So many people own a business in the US. They hire a local manager, a US employee, and they say, hey, you're going to be the local manager. You're going to do all the direct hiring. You might need to find someone you trust, obviously, but this does happen. This can be done. And consular officers know that it can be done. So if you are able to do this, and I understand many people cannot, but if you are able to do it, it can be a great way to strengthen the application. Do I get it right that I would need to secure the money for the investment and pay everything before even applying? Yes, you understand that correctly. The government wants to see that you are committed to the business. You can imagine that you're meeting up with your buddy. You've known your buddy since college. You meet up, you go grab a beer at the bar, and your buddy says, hey, you know what? I'm leaving our home country. I'm leaving Germany. I'm going to go start a business in the US. And you're like, are you serious? And you say, prove it to me. I'm skeptical. I'm not sure you really want to go. And the first thing you're going to want to know is, have you actually put your money on the line for this business? If they say, you know what, I haven't. I put my money in a bank account in the US, but I can withdraw it at any moment. You're going to be like, yeah, I'm not sure if you're actually going to go through with this. And a consular officer is thinking the same way. Putting money into a bank account in the US requires minimal commitment on the applicant's part. You can always back that money out. They want to see you're committed. If you're concerned about this, you might want to use escrow, an escrow account, which Jiyae talked about, but that is usually only if you have large assets that you need to buy. So like if you're buying a business, you might use escrow. Otherwise, there's unfortunately not really a way to get around just spending the money and committing yourself to the business. That is how, unfortunately, for better or for worse, that is how the visa is structured. Can you elaborate on buying a US franchise? A franchise is really the same as buying a business. It's actually, or a startup. You just have the added kind of infrastructure and track record of the franchise. So a franchise can be an excellent option for an E-2 visa. Reach out for a consultation if you have questions about the franchise. How much are the legal fees? Reach out, schedule a consultation. We can share that. If my wife and I are partners in the E-2 company, 60-40 partners or 80-20, could the spouse that has less than 50% apply for a work permit? Or is it better if they're not a partner? That's an excellent question. Strategically, a spouse of an E-2 visa holder. So if you are the 50% owner in the business, you get an E-2 investor visa. Your spouse, if they get a spousal E-2 visa, not an E-2 investor visa, but a dependent spouse visa, they have unrestricted work authorization. So a spouse has far broader work abilities than the E-2 investor. So it can be a wonderful idea for only one of you to apply for an E-2 investor visa and then the spouse to have unrestricted work authorization that they can use to work for the E-2 company or to work for anyone else in the US who hires them. They don't actually have to they don't have to apply for a work permit. So under current law, hopefully this won't change, when you enter the US on an E-2 dependent spouse visa, you automatically receive work authorization. Can the E-2 investor engage in part-time employment apart from the E-2 visas? No, you can only work for the E-2 company. Does London fall under this general timeframe of 3 months? In general, but that could change. Can you cancel your application after setting your interview date? Yes, you can always cancel your interview. Would it count negatively? Not necessarily. The consulates have usually third parties that are handling this. I don't think it's a big issue. You might just, worst case scenario, have to refile the application and deal with another delay. Does a smoke or vape shop, is it eligible for E2 visas? Uh, you need to be very, very careful with that because keep in mind, cannabis, marijuana, generally speaking, is still prohibited under federal law. So if your smoke or vape shop is going to have anything to do at all with any vices, which it likely will, you're going to have big issues applying for an E2 visa, and I would not recommend it. If I haven't been in my home country for a year and a half, is it something that can cause any issues? Excellent question. This is really only an issue if you are a national of the United Kingdom. Applicants from the United Kingdom need to prove that they live in the United Kingdom, not just that they have a UK passport. For basically any other country in the world that is an E2 treaty country, you only need a passport. So if you were born in Uruguay, which is not an E2 treaty country, but your parents are from Italy and you have Italian citizenship, even though you've never been there, you can apply for an E2 visa based on your Italian citizenship. Again, UK is the exception. Can startups like tech or consulting companies that raise money or funds from angel investors also apply? This is a very tricky area. Schedule a consultation because you need to put your personal funds on the line. And oftentimes angel investors also want equity. You need to own at least 50%. So it could run into some big issues. I'm going to cut it off there because we are 5 minutes over. Jiyae, thank you so much for sharing your expertise. Wonderful questions from the audience. Really appreciate those. Do check out your inbox. Keep an eye on your inbox for the email where you can sign up for future webinars. Reach out to us for any questions you have. We'd be happy to talk with you over a consultation. Thank you for taking the time. Stay healthy and stay well.